Good morning, ma'am.
Good morning, all of you. Class 8B, good morning, all of you.
Good morning, ma'am.
Good morning, ma'am.
Good morning,
Good
ma'am.
morning,
Yes,
ma'am.
good morning.
Good morning, ma'am.
Alright, so enjoyed your break? Yes, class?
Yes, ma'am.
Alright. Okay,
Yes, ma'am.
so that's nice to know that you all enjoyed your break. So now let's get back to the studies and we'll start with a new chapter in civics, the judicial system. Open your books to the chapter, the judicial system. Okay, now tell me, into how many organs our government is divided?
Ma'am, three.
Alright, name them.
Ma'am, central, state government,
Three.
local.
No, not those, Naila. They are not the organs of the government. They are the three levels of the government. I'm talking about
Okay,
organs.
ma'am.
Huh. Yes.
Legislature,
Hmm.
judiciary, judiciary.
Okay. Legislature, executive, and judiciary. All right.
Legislature
Okay. So what?
and
Huh, beta.
judiciary.
All right. Okay. All right. So what does the legislature do?
It makes laws for the country.
Okay. So it makes laws. What does the executive do?
It implements laws.
Okay, so it implements the laws, put the laws which are made by the legislature into practice. And what does the judiciary do?
It interprets the laws.
Okay, so it interprets the laws. It sees that the laws are followed, and if the laws are not followed, so it punishes the lawbreakers, it upholds the fundamental rights, and it does so many other things. So in this chapter, we will see that how our judicial system it works. Okay, so judiciary is one of the three organs of the government.
Interprets the laws.
Yes, beta. Okay, so the judiciary it does so much, and it protects the right and also our freedoms, and it checks the arbitrariness of the government. Now, what does arbitrariness means? It means that the government it does not work according to its will and wishes. All right, and so it sees that the government does not work on its will and wish and whims, but according to a proper system, a set system, and based on reason on the constitution. So the government has to work according to that, and the judiciary it protects and interprets the constitution and also maintains the authority, the power, the supremacy of the constitution. And so the work of the judiciary it can be broadly divided into three. First is the dispute resolution. So if there's any dispute, now this dispute could be between two people, between people and government, between central government and a state government, between two state governments, or between a central government or more than one state government. So any kind of dispute, and it's the work of the judiciary to solve that dispute. Okay, that is the primary function of the judiciary. Then judicial review. Now this is said to be one of the most important parts of the Supreme Court. Now Supreme Court falls under judiciary, and so it is one of the most important task or the role of the Supreme Court, and this work is the work of judicial review. Now what is it means is that the Supreme Court it has the power to see that the laws which are made by the central government or the state governments they are in accordance to the uh, spirit of the constitution, according to the constitution, and if it sees that there is any law which is passed which is not according to the constitution, then it can call that law null void, means with no effect at all. Okay, and so that is called as the power of judicial review. Now, though this term judicial review it comes nowhere in the constitution, this particular term, but still it is the power of the court to declare any legislative enactment, means any law as invalid. Now this is given by the constitution under the article 13. Then there are other articles also under the constitution, like 131 to 136, and they have also talked about the power of the Supreme Court to view the laws uh, which are passed by the central government or the state government. And so the Supreme Court is said to be the guardian of the constitution, and it also has a right to decide that whether the work is done, whether the different things are according to the basic structure of the constitution. The things that are done are according to the basic structure of the constitution. Now you know that uh, through amendments, changes can be made in the constitution, but even the parliament, they cannot make changes in the basic structure of the constitution. Now the basic structure means the main ideals on which the constitution is formed, like universal adult franchise, secularism, rights of minorities, all right, fundamental rights of the people. So now on these then the providing justice for all people, fraternity among people. So on these, the basic structure of the constitution, now this cannot be changed or amended even by the parliament. Okay, then the third important role of the judiciary is to enforce the fundamental rights. Many rights are granted to us by the constitution. Some come under the constitutional rights, like we have the right to live, and the right to vote, and the right to be voted for, the right to property, to own property. Then there's also another set of rights, very important for each person, for its for the person's proper growth and development, and they are said to be like inalienable, means you cannot take away those rights from any person. What are those rights called, by the way?
Fundamental rights.
Right, fundamental rights. Okay, and so if our fundamental rights are violated, now if they are violated by any person or an organization or even by the government, then we can go to the courts. So only the high courts and the supreme courts, they hear cases pertaining to the violation of the fundamental rights, and the high courts and the supreme courts, they have the power to issue writs, WRITS. Writs are orders to restore the fundamental rights of the citizens back to them. So if our rights are violated, we can go to the courts. Okay. So they are saying that let us recollect the story of Hakim Sheikh, and this we have read about in class 7th textbook. And he was an agricultural laborer from Bengal, West Bengal, and he fell from a running train, and his condition grew worse because the hospitals, they did not allowed him entry into any in them. And so the hospitals, they denied him entry, they refused to admit him, and so he moved the Supreme Court, and the court decided that it was a violation of the fundamental right to life, and under article 21 of the constitution, and the right to health is a part of the right to life, and so that is why his rights were violated. And as a result, the court, they directed the West Bengal government to pay Hakim Sheikh a proper sum of compensation for for his grievous injury. Okay. Now, the system of our government is such, the three organs of the government is such that though they are at the same level, but the executive is made answerable to the legislature, whereas judiciary is free and independent. Now why executive is made answerable to the legislature? Because the executive, it is the ruling government, and they are very powerful. Once in power, they can misuse the power also, and they can work according to their will, which could be against the welfare of the people. And so they are made answerable to the legislature, so that whatever they do, every policy that they make, and now it would be for the welfare of the people, and that is why they are made answerable to the legislature. And that is why if you have seen any sessions of the parliament, then there is so much confusion, and there is so much discussion and deliberation on the things which are said by the ministers and all that. And that is why, to keep their powers in check, and also to uphold the welfare of the people. Okay, now why judiciary should be independent. Now they're saying that let us suppose we are living in a system where the minister, they have the power to appoint a judge and also to dismiss him. And now if we have a property dispute with that judge, now what is most likely to happen? That the judge obviously will give his verdict in favor of the minister. Why? Because he might be scared and he might to please the judge also, and so he will give the judgment in his favor. And therefore the Constitution of India, they have provided for an independent judiciary, because if the judge will work like this, then he is not giving an independent judgment. And so the courts in our country, they are not under the government, and they do not act on behalf of the government. And the power of the powers and functions of the three organs of the government, they are clearly defined in the constitution of a country, and there is a provision for the separation of powers. Each has its own powers, and you cannot interfere much in the working of the others, though executive is made answerable to the legislature. And so the executive and the legislature, they cannot interfere in the work of the judiciary. And though the judges of the high court and the supreme court, now they are appointed by the president in consultation with the chief justice of India, and also in consultation with the other judges. But once in office, they cannot be removed from the office very easily, and they can be removed from the office only by the president, and on grounds of, like, if they have misused their office, or they have shown misbehavior, not proper for a judge of the high court or the supreme court, or incapacity means they have not been able to perform their work or do their work properly. So only in those cases a judge can be removed, and that also not easy just like that. And to do this, a resolution has to be passed in both houses of the parliament. Just like the way a law is passed in the parliament, that it is presented in one house, and then it has to get approved from that house, goes to the other house, the other house also has to approve it, and then only it can go to the president for its approval. So in the same way, a resolution has to be passed in the parliament, and this has to be passed by two-third majority. And otherwise the rest of the bills are passed by simple majority, but these matters, they have to be passed by two-third majority. Means the two-third members have to give or have to vote in favor of the resolution. And then only a judge can be removed. And now, so the removal of a judge is a very difficult process, and till the time there's a proper agreement, a general agreement among the members, you cannot remove a judge like that. And the constitution, it also forbids that you cannot discuss about the conduct of a judge in the parliament just like that, till the time a resolution has been passed. So only when a resolution has been passed, then only you can talk about the judge, that why you want to remove it and about his conduct. But otherwise you cannot talk about the conduct of a judge in the parliament just like that. And even the salaries and the allowances of the judges, they cannot be changed while they are in office. And there are other also provisions which ensure that the judiciary, it works independently. Now it is necessary that we have an independent judiciary, so that the judges, they can work, they can discharge their duties without any fear or favor, and now, and without even any interference of the legislature or the executive, because the legislature and the executive, both are very powerful bodies. Legislature is the law making body of the country, and the executive is the ruling government. So both are very powerful bodies, and so that is why there is no interference of these two bodies in the matter of justice or in the judiciary system. Now that also does not mean that the judiciary can work as its according to its will. Now the judiciary also, they have to follow the constitution in letter and spirit. Means whatever is written in the constitution, they have to follow that, and also keep work according to the ideals, the spirit of the constitution. Okay, so now this was that why we need an independent judiciary and the role of the judiciary. Now we'll see how our judicial system is. Now the Constitution of India, they provide for a single integrated judicial system. Now what that means is that like some other federal countries of the world. What are federal countries, by the way? What is the federal system of government?
A system in which the powers are divided between the central government and the state government.
All right. Okay. So, a system in which the powers of the government are divided, or the power to rule are divided between the central and the state government. In many federal countries, the states they have their own independent judiciary. But in India, the whole judicial system, though we are a federal country, but still the whole judicial system is single and integrated. So, what that means it is in the form of a pyramid. At the top we have the Supreme Court. Under the Supreme Court, at the state level, we have the high courts, and under the high courts we have the subordinate courts or the district level courts, and under it we have the lower level courts. And the lower level courts, they work under the direct superintendence of the, or the direct supervision of the higher courts. Okay, now the structure of judiciary, let's have a look at this green box. Some information is provided here, that the structure of judiciary is in the form of a pyramid, consists of one Supreme Court in Delhi. They have 31 judges, and then we have 24 high courts, and then they can have at least 725 judges, and at the subordinate level we can have 14,447 judges. Now, the Indian High Court Act, it was passed in 1861, and as a result, high courts came up in the three presidencies under the British India, that is Calcutta, Bombay and Madras. Then the High Court at Allahabad, it came up in 1866, and it had its authority over the territory of UP, and it has a bench at Lucknow. Then the Delhi High Court, it was established in 1966. Then the High Court of Punjab and Haryana, it also came up at 1966 at Chandigarh. And Punjab and Haryana, they share a single High Court. Then or a common High Court. Then there is a common High Court at Guwahati for Assam, Arunachal Pradesh, Mizoram and Nagaland, whereas Manipur, Meghalaya and Tripura, they have their own separate high courts. Then in the year 2000, three more high courts were established, one each at Bilaspur, Nainital and Ranchi, and they had their area of authority or their jurisdiction over the states of Chhattisgarh, Uttarakhand and Jharkhand. Okay, so we were talking about the structure of the courts. At the top level we have the Supreme Court, under it at the state levels we have the high courts, and under the high courts we have the subordinate or the district level courts. And these levels at the district court, district level or the tehsil level, they hear many kinds of cases, and normally we first come in contact with these courts or the district level courts. And the whole country is divided into so many states. Each state is further divided into several districts, and each district is presided over by a district judge. And each state has a high court, and which is the highest court of the state. And some of the smaller states, we have just seen that they can share a common high court also. So the high court is presided by the Chief Justice of the High Court. The district level courts are presided by the district judge. Then the High Court is presided by the Chief Justice of the High Court. And at the top, that is the national level, that is the Supreme Court, which is located at the country's capital, that is New Delhi. Now that is presided by the Chief Justice of India. So the Chief Justice of the Supreme Court is called as the Chief Justice of India. And the decisions which are made by the Supreme Court, they are binding on all the courts in India, and likewise the decisions which are made by the High Court, they are binding on all the lower courts. Now our Indian system also has an appellate system of jurisdiction. Now what does appellate system means? That through appeals a case can move up from the lower courts to the higher courts if a person is not happy with the verdict given. And so if it is not convinced with the decision from the lower courts, he can go to the High Court and then to the Supreme Court. And the decision of the Supreme Court is final and binding on all the courts in India. And this is what we mean by a single integrated judicial system. Now just to have a quick look at what is this appellate system of jurisdiction. So we'll have a look at a case. Now this case was the state of Maharashtra versus Sandhya Jadhav and others. This was in 2006, and this moved on from the trial court to the Supreme Court. Now let's see what happened. Now the main accused in this case was Sandhya Jadhav, and there were some people co-accused with him, and these people were residing as tenants in the house of Govind Rao Goratkar. So on this particular day, that is 6 June 1990, the landlord he went to the accused to ask for rent, and then a fight came up between them, and the accused people they assaulted the landlord, and so the landlord's nephew Anand Goratkar he intervened, and Sandhya Jadhav, what he did, he attacked him with a knife and killed him. So a complaint was lodged by Govindrao Goratkar, and the brother of Anand Goratkar, means the person of the deceased, and the police they registered an FIR. And when the FIR is registered, what is an FIR, by the way? Full form of FIR?
First information report.
Right, first information report. And so the on the basis of the FIR, the police they started an investigation, found certain evidence, and they arrested the accused. And so the accused were charged with committing murder. And so the case it opened before the trial court, and in reply to the charges, the accused people say that they were not guilty, and they gave a common plea that on the day of this incident, Govindra Goratkar he came along with 5-6 people, and they started to beat them. But the prosecution they were not convinced, and so on the conclusion of the trial, they gave the verdict that the accused were guilty of the charges, and then sentenced them to life imprisonment. Okay, so the accused were not happy with the verdict, and they appealed before the high court, and they took the stand that it cannot be brought, this case cannot be brought under section 302 of the Indian Penal Code as intentional murder. Why? Because the occurrence it took place in the course of a sudden quarrel, means they came there, they asked for money, a quarrel, then fighting started, and in the process of this fight, they said that the landlord and his nephew they were the people who were being aggressive, and it was the right of self defense which was there for Sandhya Jadhav, and this murder this did not take place because it was premeditated or intentional, and it just took place in a sudden quarrel, and so section 302 of the IPC did not have any application there. And they also pointed out that there was no intention to kill because there was just one single blow of knife. But the Nagpur bench of the Bombay High Court, they did not accept this, and they upheld the judgment which was given by the trial court. And then finally the accused they appealed before the Supreme Court, and the Supreme Court judge he was convinced that the murder it was unintentional, and it was without any premeditation, and so death it was simply caused by a single blow and in a sudden fight. And so the this whole thing was changed to section 304 part 2 of the Indian Penal Code instead of the section 302 of the Indian Penal Code. And so the life imprisonment of Sandhya Jadhav and his co-accused it was changed to imprisonment for 7 years. So that is how, if you're not happy and satisfied with the verdict given by a trial court, you can move up your case from trial court to the Supreme Court through appeals. Now this is what is called as the appellate system of jurisdiction. Okay, so have you all understood till here? Any questions, class?
No, ma'am.
What about the rest? All understood?
Yes, ma'am.
All right.